In Malaysia, Section 17 and 18 in defining fraud and misrepresentation do not expressly provide that the act or representation must induce the other party to enter into a contract before it can be effective. However, the explanation to Section 19 provides that if a fraud or misrepresentation did not cause the consent of the party, such act would not affect the validity of the contract. This principle is established in the case of Hoffer and Thomas. Unlike common law, no one is entitled to make a statement which on the face of it conveys a false impression and then excuse himself on the grounds that the person to whom he made it had available means of correction. This is clarified by Lord Dundee in the case of Nocton and Lord Ashburton. Subsequently, in the case of Mutulai and Life Insurance Corporation, the Indian Supreme Court clarified that the explanation to Section 19 states that a false misrepresentation, whether fraudulent or innocent, is irrelevant if it has not induced the other party to whom it is made to act upon it by entering into the contract. The position of Malaysian law in terms of burden of proof of inducement is similar to the initial position in English law prior to the enactment of Section 2 of the Misrepresentation Act 1967. In conclusion, the position in English law is that the burden to prove that there was no inducement of the misrepresentation is always on the defendant, whereas in Malaysia, the burden of proof is contingent on whether a reasonable person would have been induced.